I thought traffic in LA was bad, but then I drove on the New Jersey Turnpike. Y'all are crazy, and that's with totally normal driving laws in effect.
78 and the New Jersey Turnpike are far worse than what I'm doing in this truck, that's for sure.
Now, you may think that I'm some elite lawyer who spends Sunday morning reading William Blackstone's commentaries on the laws of England, but I'm just like any other red-blooded American male. Sometimes I wake up on Sunday morning determined to buy a Cybertruck, festoon it with truck nuts, and then curse out pedestrians as I head on down to the nearest beach to shoot a whale for my car. Unfortunately, our nanny state government explicitly prohibits these exact activities. But these are just some of the weird traffic laws that are still on the books. Though, admittedly, some are crazier than others. I don't think I'm gonna miss out on whale hunting for my car anytime soon. But for instance, South Carolina law bars any, quote, sticker, decal, emblem, or other device containing obscene or indecent words, photographs, or depictions from appearing on a vehicle. The statute does not clearly define obscene or indecent, leaving room for subjective interpretation of law enforcement and the courts. And as we know, bad things happen when the police aren't given clear legal standards. Bad things like little old ladies being dragged into court for obscenity charges. And that's exactly what happened to 66-year-old Virginia Tice, who had the balls, pun absolutely intended, to put some 8-inch truck nuts on her pickup. One morning, Tice needed to run some errands, so she took her truck for a swing through Bonao, South Carolina. The chief of police, Franco Fuda, was not having any of it. He pulled Tice over, ordered her to remove the truck nuts, and slapped her with a fine for $445 for displaying obscene items. But not surprisingly, a defense lawyer jumped on the case, arguing that the statute violated her First Amendment rights. But the humorless Chief Fuda said that he couldn't think of any way that this could be a free speech issue. He said, quote, "I don't know what they would be trying to express. I went to a few websites that said, excuse the expression, show your nuts. I didn't see anywhere it said support your local proctologist or farmer." Now, who knows where the chief got the expectation that it's only expression if you understand the message, or if it's in support of proctologists or farmers. What is the farmers thing anyway? But the question was, is the state's ban on truck nuts constitutional? Well, as the Brits might say,
bollocks.
Generally, the First Amendment does not ban vulgar speech unless it falls into specific unprotected categories such as obscenity. And for example, the South Carolina law tracks the definition of obscenity as it applies to hardcore pornography. For materials to meet that standard, it must be sexually explicit in a way that appeals to prurient interests. Prurient here being an old-timey word for horny, and it must be patently offensive under community standards and lacking serious literary, artistic, political, or scientific value. Now, it seems clear that the plastic testicles on Tice's truck do not meet this standard. They were neither sexually explicit nor likely intended to incite prurient interest, and you can interpret the display of family jewels in a variety of ways, and not all of them are sexual. One might even argue that they were hung as a clear expression of how Tice thought about her big bad boy truck. And a reasonable person would not conclude that this was overtly sexual in nature. And Eugene Volokh, my former law professor and an expert on First Amendment law, thinks that the South Carolina law is unconstitutionally broad, and he's probably right. A statute is considered overbroad when it extends beyond its intended purpose, regulating more speech than is necessary or allowed under the Constitution. And when statutes are overbroad, they create ambiguity, allowing people to impose their own subjective interpretations of what constitutes appropriate speech. The chief obviously had his own ideas about what this little old lady was expressing, but under the First Amendment, it doesn't really matter how he interprets her expression, nor whether or not he approves of it. And that's why the story has a happy ending, if you support truck nuts. After a judge sided with Tice, the state dropped all charges. So as we've said time and time again, America is the land of D's nuts.
And the home of D's nuts.
But it's not all American flags and freedom. 12 states still prohibit buying a vehicle on a Sunday. Why? Because of very old laws designed to stop Americans from giving in to the spurious impulses like dancing or buying a Cybertruck on the Lord's Day. These are known as blue laws, regulations that ban certain activities on the Sabbath, often Sunday, historically to promote observance of Christian worship. Blue laws typically restrict the sale of alcohol and prevent businesses from opening on certain days. In South Carolina, again, for instance, it is still illegal for dance venues to be open on Sunday. And we did a whole video about Footloose-style dancing bands that you should watch if you're itching to bust a move inside of a church.
The beat of music, the curves of the body, the display of the outward person, we don't believe is congruent with the principles of Bible doctrine especially.
But blue laws are as old as America itself. The Jamestown Colony created the first set of blue laws in 1610. They were called the, quote, Laws Divine Moral Martial, apologies for anyone that speaks Old English, and the punishments for breaking them was brutal. If a person spoke disrespectfully of the clergy, the penalty was a dagger through the tongue. And you could be punished with death for, quote, blasphemy, uttering treasonous words or words critical of the company, murder, sodomy, robbery, swearing false oaths, bearing false witness, trading with Indians without permission, stealing from Indians, cheating the company or the Cape merchant who operated the company's storehouse, trading with sailors without permission, and sending goods out of the colony without permission. There were so many ways to get the death penalty back then, it's probably no wonder that 80 to 90% of the Jamestown colonists died within a year of arriving in America. But thankfully, in modern times, selling or buying a car on Sunday does not warrant a death sentence, although maybe buying a Pontiac Aztek or Tesla Cybertruck should. But even if you buy your car on a Saturday, you probably shouldn't go out shooting animals from moving vehicles in California. In California, you are not allowed to shoot animals from your car. California Fish and Game Code section 3002 says, quote, it is unlawful to shoot any game, bird, or mammal, including a marine mammal as defined in section 4500, from a powerboat, sailboat, motor vehicle, or airplane. But the misinterpretation of this law has become urban legend. Many websites, including blogs run by practicing attorneys, putatively, claim that because the statute only lists birds and mammals, it's actually legal to hunt whales from a moving vehicle in California. Well, I'm sorry to all you burgeoning Captain Ahabs, but this legal loophole is not a thing. In California, marine mammals include sea otters, whales, dolphins, porpoises, seals, and sea lions. You can't shoot any of them from a boat or a car. And the taking of whales is exclusively governed by federal law. California Fish and Game Code section 4500 explicitly recognizes this, saying, quote, it is unlawful to take any marine mammal except in accordance with provisions of the Marine Mammal Protection Act of 1972. So luckily for Shamu, the states don't have jurisdiction over whale hunting, and the feds aren't eager to grant hunting licenses either. It actually took until June of 2024 for the National Marine Fisheries Service to recognize the whale hunting rights given to the Makah tribe under the Treaty of Nea Bay of 1855. So please don't hunt whales or any other mammal, including humans, from your car, no matter what your online attorney tells you. Unless you're in Los Angeles and it's open season on the 405.
Open season on the LA freeway.
Now, unsurprisingly enough, Iowa is more permissive of hunting from a car than California, but it's only for a reason that might actually surprise you: accessibility. In Iowa, the law says, quote, except where prohibited by law, a handicapped person meeting the conditions of this rule may shoot from a stationary motor vehicle. Handicapped persons may use certain motor vehicles on game management areas according to the restrictions set out in this rule in order that they might enjoy such uses as available to others. Now, this may not have been what was on Congress's mind when they passed the Americans with Disabilities Act, but it makes sense. The law was intended to help people with disabilities participate in the same activities as everyone else. So it makes sense for states to provide accessible hunting areas. Accommodations can include things like accessible blinds, designated hunting areas, or modified hunting equipment, which makes this law surprisingly progressive for a conservative state. But once again, I must remind you, regardless of what kind of accommodations you get, you must not give in to that temptation to hunt the world's deadliest game, man. Despite how thrilling and how much of a rush you might get, you must not give in to that temptation. But also, don't honk your horn if you want a sandwich in Arkansas. Because if you're driving through Little Rock, Arkansas, and you stop to get a bite to eat, you may be at risk of unintentionally committing a crime. That's because it's illegal to honk a horn at any dining establishment while parked. Quote, it shall be unlawful for any other person parked at the premises of a drive-in restaurant to blow or cause to be blown any automobile horn or motorcycle horn at any time while parked. This law may have been intended to stop diners from being jerks to servers, which may come as good news for anybody who works at one of Little Rock's many Sonic drive-thrus. But the law doesn't stop with drive-in restaurants. It also applies specifically to sandwich shops. Municipal Code 1961, section 25-74 says, quote, no person shall sound the horn on a vehicle at any place where cold drinks or sandwiches are served after 9 p.m. Now, is a burger a sandwich in the eyes of the law? Let us know what you think in the comments below, but I'm sure Sonic's employees are eager to know. Okay, so Little Rock really doesn't like the sound of car horns. I don't know if anyone really likes the blaring sound of a horn at any time of the day, but honking your horn while parked at a sandwich shop or otherwise may be a form of protected speech. Think of, say, responding to a sign in the parking lot that reads, honk if you like sandwiches. But on the other hand, noise ordinances are often upheld as a valid exercise of the state's police power. However, to comply with the First Amendment, noise ordinances must be content neutral, meaning they regulate the noise based on volume, location, or timing rather than the message being conveyed. And in the seminal case on this, Ward versus Rock Against Racism, the Supreme Court upheld a New York City ordinance requiring sound to be controlled during a rock concert. The court confirmed that a music concert was a form of free expression. However, the court concluded that the restriction was a time, place, and manner restriction rather than an attempt to censor or control the message of the music. Justice Kennedy wrote that the ordinance, quote, must be narrowly tailored to serve the government's legitimate content-neutral interests, but that it need not be least restrictive or least intrusive means of doing so. So could Little Rock's law be deemed unconstitutional or perhaps upheld as constitutional? We don't know unless someone challenges it. Now, obviously, if you're going to break any traffic laws, even incredibly silly traffic laws, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you've got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Now, speaking of noisy cars, in Derby, Kansas, you can't squeal your tires unnecessarily. Ordinance number 2717 says, quote, it is unlawful for any person or persons while operating a motor vehicle on the streets or highways of the city to accelerate or speed the vehicle in such manner or to turn a corner in such a manner as to cause the tires to screech. Now, violators are guilty of a misdemeanor and if convicted can face a fine of up to $500 or 30 days in jail. But how does Derby define exhibition of speed or acceleration? Well, quote, exhibition of speed or acceleration means those acts which cause or create unnecessary rapid acceleration, unnecessary tire squeal, skid, smoke, or slide upon acceleration, or stopping, including the casting of tread, gravel, dirt, or other road surface materials from the tires, acts that simulate a temporary race, acts that cause the vehicle to unnecessarily turn abruptly, sway, or lose traction with the road surface. Now, obviously, this kind of statute is designed to prohibit drivers from engaging in reckless, dangerous, or disruptive behavior like street racing, burnouts, or intersection takeovers. But while most laws simply forbid these activities outright, the wording on Derby's laws opens it up for a challenge as a violation of First Amendment rights. The general idea is that, like honking your horn, tire squealing in and of itself could be construed as expressive conduct. However, courts generally do not see it as such. Laws targeting behavior like reckless driving are usually treated as regulating conduct, not speech. And courts have recognized that nonverbal conduct, including sound or noise, can sometimes fall under First Amendment protection if the creator intends for the noise or sound to convey a specific meaning, and if there's a likelihood that the audience would understand the intended message given in context. But regardless, you might want to think twice before taking a turn a little too quickly if you're in Kansas. But in any event, don't curse while you're driving in Rockville, Maryland. This one hits close to home. Literally. Now, I'm sure we've all used some pretty explicit language when behind the wheel, but doing so in Rockville, Maryland could land you in legal trouble. You can check out Local Ordinance 13-53, which says, a person may not profanely curse and swear or use obscene language upon or near any street, sidewalk, or highway within the hearing of persons passing by, upon or along such street, sidewalk, or highway. A person may not act in a disorderly manner by profanely cursing, swearing, or using obscene language. So if you get busted for cursing in Rockville, you can face a fine of up to $100 and or jail time of up to 90 days. Now, frankly, it is hard to believe that anti-cursing laws are still on the books in America, but they are, as you can imagine, rarely enforced. That probably explains why no one has challenged this particular law in Rockville. And anti-cursing laws in general are on incredibly shaky ground because the government may not punish the use of profane or vulgar words simply because they are offensive, but only if they're used for the explicit purpose of inciting acts of violence. You might have heard of the idea of fighting words. The Supreme Court addressed the concept of fighting words in the landmark case of Chaplinsky versus New Hampshire in 1942, and the court defined fighting words as speech that by their very utterance inflict injury or tend to incite an immediate breach of the peace. These are words that are theorized to be likely to provoke a violent reaction from the listener. Such words are not protected by the First Amendment because they do not contribute to the expression of ideas or have any social value. But as you can imagine, this kind of scenario rarely happens, and it's not even clear that this is still good law. It's really hard for a state to legitimately ban fighting words. Later cases have limited the reach of the Chaplinsky case, and modern courts are skeptical of anti-profanity laws. For example, in the case of State versus Elibanjo, police in North Carolina arrested Samantha Elibanjo for using profane language toward a police officer on a public street. She was charged under a state statute that made it a crime to use indecent or profane language on public roads. The North Carolina Court of Appeals overturned her conviction, ruling that the statute was unconstitutional. The court emphasized that while some forms of speech, such as fighting words, are not protected under the First Amendment, the language used by the defendant here did not fit that category. And the court found that the statute was overly broad and infringed on free speech rights because it criminalized protected forms of expression. Thus, the conviction was reversed, highlighting the importance of free speech and limitations on government regulations of offensive conduct. Now, driving laws in the US are weird, but they're often even stranger in other countries. For example, Sweden is a country where the sun only sets for a few hours during the summer, and yet you are required by law to keep your headlights on at all times. We go into why this law exists and examine many other strange traffic laws across the world in the extended cut of this video, which you can only see if you sign up with today's sponsor, Nebula. Because on Nebula, you can watch all of our videos ad-free and early, because our videos always go up on Nebula first, plus there's tons of exclusive content. And for a limited time, you get a lifetime membership you can buy once and then never again. It is the greatest deal of all. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. I've heard it described as Netflix for people who like trains, with your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and your most favorite, Legal Eagle. And exclusives on Nebula are getting really good, like the latest season of Jetlag, where your favorite creators play geographical games all across Japan. And you can watch my exclusive feature-length documentary, Bad Law Words Good, as well as my full-length interview of the screenwriter by Cousin Vinny, and my Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is it is a creator-owned platform built by me and other YouTubers and podcasters, and because it's a subscription service, we get to work on larger, higher-budget productions than we ever could anywhere else. And it's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And for those of you that want to share everything Nebula has to offer with friends and family, Nebula is now offering annual gift cards. And if you sign up using the link that's on screen right now, you can give a year of Nebula to a friend for 40% off the yearly subscription. A year of the best content for just $36. And that's a gift that you can give to yourself, by the way, because you deserve it. So get 40% off of you or a friend's yearly subscription at just $36 a year, or you can check out the lifetime deal where for $300, you can get access to Nebula forever. We're investing in more big concept, high octane Nebula originals, and your lifetime subscription goes towards that investment. In a way, lifetime is the best possible deal of all. Either way, you'll get my videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on our own streaming site. So sign up now and get you or a friend 40% off of Nebula at $36 a year, or get the incredible lifetime deal by clicking on the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.